The prosecution, the defense basically centered their points, their arguments on the amendments made in the Fugitive Offenders Act. And the prosecution obviously responding, mainly citing that the arguments that they're making are issues that have to be raised and resolved in the High Court. Legally, as the Attorney General, we just want to hear from you as to what is your take on what happened in court today.
So, as you know, the defense said on the last occasion that they want to raise some constitutional issues which the magistrate is obliged to refer to the High Court for determination if the magistrate finds that those issues that are raised are not frivolous and vexatious. In other words, if the issues are frivolous and vexatious, the magistrate can dismiss them and proceed with the extradition hearing. And that is what the magistrate ordered both sides to put their submissions in writing in relation to that matter. It's a special procedure that the Constitution allows when matters are in the magistrate court, because the magistrate is not a tribunal that can resolve or address constitutional matters. But as I said, the magistrate has an overriding discretion to dismiss these issues when they are raised if the magistrate is of the view that they are frivolous and vexatious. The defense raised a number of issues. They said that the 2009 amendments, which you made reference to, are unconstitutional. The truth of the matter is that that issue has already been reviewed. Those arguments have already been advanced and conclusively adjudicated upon by a judge of the High Court and rejected as wholly without merit. And the case is Marvin Williams against the Director of Prisons. You would have heard them mention that case. That case was decided in 2018 or 2019. So quite recently, the High Court of our country examined all these very arguments and rejected them out of hand. I had a look at the defense submissions, and I don't think they mentioned that in their submissions. They said that our treaty with the US is deficient. We have two Court of Appeal decisions, one by the name of Garfield Sobers against the Director of Prisons, and one Stephen King against the Director of Prisons. One decision was given by Chancellor George and Justice of Appeal Bishop and Justice of Appeal Kennard. The other one was given by Chancellor Kennard and two other Justices of Appeal. And the very deficiencies that they are saying that our treaty has, those two Court of Appeal rulings examine the very argument and the very contentions and ruled that the treaty has no such deficiencies. This is a 1935 treaty. The two decisions I am referring to were given over 30 years ago. And we have been extraditing people to the US over the last 30 years on a regular basis using the same treaty because we have two decisions of the court saying that the treaty is not deficient as they are now alleging. The point I am making is that none of the arguments are new. They are well trodden paths that we have traveled before, and we have rulings coming from higher courts, which rulings are binding on the magistrate. You know, we operate under what is called the doctrine of precedent. And in the doctrine of precedent, there is the principle of stare decisis. And that principle says that the decisions of a higher court are binding on a lower court. So the magistrate, being a lower court, cannot depart from those very clear and conclusive determination of those very issues that are being canvassed now by superior courts. More so, our Court of Appeal, which at the time was our highest court in Guyana. That is long before the CCJ came. The other issue that I think they advanced is that there was a full court decision. A full court is a division of the High Court in a case called Barry Dataram. And they are saying that Barry Dataram says that the treaty is deficient. Now, Barry Dataram was decided without any reference, without the Barry Dataram court being a lower court in our Court of Appeal, refusing to follow Sobers and Stephen King, which were higher courts, and the judges in Barry Dataram were bound by that decision. But for whatever reason, they felt that they should not follow it. In subsequent cases, judges have commented on Barry Dataram, saying that it was wrongly decided. So it is not open to a magistrate to follow Barry Dataram when you have two courts higher than Barry Dataram that went the other way. And you have subsequent cases after Barry Dataram from the High Court saying that Barry Dataram was wrong. The point I am making is that the magistrate is bound by the higher court's decision. And the Caribbean Court of Justice only recently, in the case of Vikash Ramkisoon and Sarah Brown, two names that you are familiar with. Remember, they had a case that went all the way to the CCJ in relation to their position in the parliament as parliamentary secretaries. That case was determined in 2024 only last year. And the CCJ confirmed the importance of the doctrine of stare decisis and the doctrine of precedent, that lower courts must consider themselves bound by higher courts' ruling and decisions. So the principle is intact. Then there is another issue. They're saying that because of these treaty deficiencies, and I'll deal back with the treaty deficiencies just now, certain constitutional rights of theirs are violated. But when one examines what extradition proceedings are, they are not trial. There's no charge in Guyana in relation to these persons. Those fundamental rights and freedoms that are guaranteed by the Constitution, insofar as they are relevant, they apply to persons facing a criminal charge filed in Guyana and who are going to stand trial in Guyana. There is no charge against these two persons in Guyana, and they are not going to be tried in Guyana. And the very provisions of the Constitution that they are relying on accepts extradition proceedings. In other words, the very provisions that they are relying on, the right to liberty, the right to a fair trial, the right to freedom of movement, those provisions in the Constitution themselves say that they do not apply to extradition proceedings. Right? The third issue that I believe they raised, is, and it goes back to the treaty deficiencies. They are saying that the treaty is deficient because the treaty doesn't have a particular safeguard that protects these two persons from being tried for offense other than the offenses for which they are extradited, or protects them from being extradited to a third country once they go to the United States. Now, as I said, our treaty provides for that and provides the necessary safeguards against that taking place. So it is not correct that the treaty is deficient. And as I said, we have two cases from the Guyana Court of Appeal that make that position extremely clear. So the treaty, as I said, is not deficient. However, out of an abundance of caution and to put their fears at rest, right, and not to embark on unnecessary long litigation, we got from the U.S. an assurance in writing that should these people be extradited, they will not be tried for offenses other than that for which they have been extradited. Neither would they be extradited to a third state without the permission of the government of Guyana, because that is what they are complaining about. And in order to offer them due process, to allay their fears, and to avoid unnecessary argumentation and unnecessary litigation, though we don't need it, the Americans have given the assurance. That removes the foundation from their complaint, because that in essence is the only thing they have complained about. In substance, I am told that they were disappointed rather than be elated when we supplied the assurance in the form of a dipnote. And they want to address the magistrate on that further. And I'm told that the magistrate extended some time for them to do so. But the truth of the matter is, they have made a complaint, and we have acted upon it and given them that which they are complaining for. They are saying that this is deficient because this thing is not there. But we have given them the thing. So how can that be a bad thing? They ought to be very happy that it is so. And it is all part of the state's responsibility to ensure that due process is accorded, to ensure that the constitutional rights are respected, that the Constitution is obeyed, that our treaty obligations are discharged, and whatever legal and protective safeguards these persons as citizens of Guyana are entitled to, they get from the state. And in the discharge of that responsibility, we solicited that assurance from the Americans, and the Americans gave it willingly.
Eji, now that submissions have been made on both sides, what are the possibilities? When's it set for ruling by the magistrate? Either. What
So the magistrate, there's two options that are available. One, the magistrate can uphold their submissions and refer the questions to the High Court for determination. Or the magistrate can dismiss their application and rule as she is empowered to do under the Constitution, that the questions raised are frivolous and vexatious, in which case the magistrate is then required to proceed to embark upon the committal hearing now. A committal hearing to it, whether or not to extradite, to make the committal order to extradite. The decision to extradite is that of a minister, not that of the magistrate. All the magistrate is required to do is to say that there is sufficient evidence to extradite and to make the order for extradition, or don't make the order for committal, sorry. It is the Minister of Home Affairs who makes the decision whether to extradite or not.